titled Getting Your Key Employees Back into the U.S. under the DOS's National Interest Exceptions, a conversation about eligibility and process. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. This session is being recorded. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. And at this time, I would like to turn it over to Masa Aliasgari. Masa, please go ahead.
Thank you, everyone, for joining us. We appreciate those of you who've taken the time to join us in our latest pop-up session that we've scheduled. As some of you who are used to joining us on our webinars and our sessions know, we tend to do these a lot these days. There's a lot of changes taking place on a regular basis, sometimes daily, and we hope that this session will provide a little bit of clarity to the extent that we can provide as it relates to the most recent travel restrictions, entry restrictions, and visa bans. We're going to take a minute to introduce ourselves on the panel, and then we'll get right into the topics. Again, my name is Masa Aliasgari. I am a senior counsel based out of our downtown LA office in California. I've been practicing immigration for about 2 decades, both on the benefit side, supporting visa processes, but also on the compliance end through investigations and audits involving DOL and USCIS and ICE. I'm going to turn it over to our next speaker, Diane.
Thanks, Masa. I was able to work as a foreign student advisor about 4 or 5 presidents ago and got the bug and really enjoy doing immigration, and I've been doing it ever since.
Thanks, Diane. Gabe? Gabe, you're on mute.
All right. Thank you. Can you hear me now?
Yes.
So I got the immigration bug by being a first-generation American here in the U.S. Family immigrated over from Romania many, many years ago. I've been in the immigration space now for about 2 decades, just like Masa. I'm partnered with the practice over in Atlanta. I'll hand it over to Angelo.
Thank you. I'm mathematically challenged, so I can't tell you how many presidential terms I've been practicing immigration law, but I do know that it's more than 4 decades, and I got the bug long ago from my heritage. My grandparents came from Italy, and I'm excited about this program because it's one of the rare opportunities when we can go behind the consular post walls and look at what consular officers do, which is not always well understood.
Great, so let's get started. What we want to do for starters is just set the stage for everybody and provide some context. We want to first say, and this is to Gabe's great point, there's a difference between an exception and an exemption. And today we're going to shine some light on that. In particular, we're going to look at an announcement from last week, from August the 12th, that opens the door for more opportunities for people to come back to the States. And then we want to actually lay out the logistics of how you would go about approaching the consular posts on behalf of your employees to bring them back. And then at the end, we would be very happy to take your questions. Next slide, please. So to further set the stage, even though we have had no major or minor immigration legislation since January 2017, we have in fact seen a dramatic change in the immigration landscape since then. And that's been accomplished by this administration through a variety of memos, executive orders, interpretations, announcements, and more recently, proclamations. And it's really an ongoing deluge, as the slide says. So if you're not keeping up, you are to be forgiven. Today is an opportunity to help you catch up because there really has been so much going on. In the last 6 months alone, we can focus on even more that's been going on. To set the stage further, we want to talk a little bit about the agencies that we're dealing with. So there is no one agency that runs immigration for our country. It's really a consortium, starting with the Department of State. So even though everybody in the State Department rolls up to Mr. Pompeo, it's true that the different consular posts around the world are often like fiefdoms unto themselves, meaning they have local rules, they have local procedures. So you always want to keep that in mind, and you always want to check directly with the consular post that you're going to be dealing with. Another agency we deal with a lot is the Department of Homeland Security, and under DHS, there's Customs and Border Protection. Those are the people in the uniforms who take care of the border, either the airports or the ports of entry at the land borders. And then there is the Service Agency, which is United States Citizenship and Immigration Services, and they're charged with responsibility for approving benefits for people who are immigrants. A big question we ask almost daily is, are all these agencies talking to one another? And with that, I'm going to turn it over to Massa.
Thanks, Diane. And that really does delve into what is being issued in terms of entry restrictions versus visa bans, and then how are these different agencies dealing with them, because that impacts how we can guide employers and your associates on how and when, where you can travel. And that's been a bit of a problem because much like the administration in general, we're getting guidance and policies piecemeal and in different formats, including tweets from the Department of State early on when we really didn't know how they were going to take those proclamations and entry restrictions and apply them. But let's start with talking about one of the first things that came out, and that really relates to the travel restrictions. And those are specifically entry restrictions, right? And they apply across the board, regardless of visa status, and they apply specifically to, individuals coming from certain areas. So it's not really about whether you have a visa or not. It's not about what your nationality is. It's really physically, geographically, where were you before you attempted to enter the US? And in particular, we have specific areas and countries that are part of this entry restriction, right? So that's countries in the Schengen area. And you'll see we provided this little a snippet of who is covered under the Schengen area, because there is some confusion there. It's not all of EU. It's just the specific countries within the area, the 13 European countries. It includes China, and that was the first country to be included in the entry restrictions. It includes the United Kingdom and Brazil and Iran. So really here it's about, if you're trying to come into the US, have you been in one of those countries? And if you have to go through a 14-day quarantine outside of those areas before you're allowed to enter the US. And there can be requests submitted to get an exception from this, and we'll talk about that a little bit later. And US citizens and legal permanent residents are able to enter without the quarantine as well. And there's other individuals who are also can get exceptions to this 14-day quarantine. And there's been confusion about that, so we wanted to make sure we first identified the difference between this entry restriction versus our presidential proclamations that came later that really are more of a labor market induced ban. I'm going to let Angelo talk through kind of what that entails with the proclamations.
Well, thank you, Masa. The labor market ban began back in April and then was expanded later. And the two presidential proclamation numbers are shown. When it was renewed, that's when things got very difficult for those concerned about work visas, because it extended the immigrant visa ban, but created a work visa ban that would cover specific categories of all H-1B except for H-1B1, which we'll get into, all L-1 categories, many J-1 categories, and we will distinguish which ones are covered and which are not, and then the H-2B non-agricultural worker category. The ban did not cover F1 students. Rather, that arose as a result of an Immigration and Customs Enforcement publication on its website purporting to eliminate the permission to engage in online education that was available to F1 students. That led to a lawsuit brought by Harvard and MIT, and it made me proud because it was done in a matter of days and was extremely well written and authoritative. It was so strong that the Department of Homeland Security and ICE backed away and withdrew that announcement. But in a matter of a few days after that, they came back with a less difficult standard for many to meet, as long as there was some incoming students who are not in the United States who are going to be engaged in 100% virtual education, they would not be allowed in. But a hybrid virtual and in-person would be allowed, with each educational institution allowed to describe the allocation of time between in-person versus virtual. And so that's where we are with students. We'll not be covering students any much more unless there are specific questions. We can go to the next slide. Go ahead.
Out of curiosity, I know for our clients who sponsor H-1Bs and L-1s, et cetera, you know, the first part of this is really important. Why do we care about the F1s? Diane, Gabe, thoughts on that?
Well, as the former DSO, I'll step in on that. We care about the F1s because they're a talented group of people, and many of them are a source of highly qualified labor. When they graduate, they have an opportunity to remain in the US for 1 to 3 years and work. So many of the people who become H-1Bs started their lifetime in F1 status.
So this is really
and what's
troubling.
a DSO, Diane?
Oops, sorry.
Sorry, a DSO is a designated school official.
Yeah, and this really hits on the pipeline, right, of your talent that you might be otherwise have access to. You're losing that. Think of your PhDs, think of your grad students, that, you know, those brilliant minds that may not be coming out to the US. So I think that's why we saw MIT and Harvard take such a strong stance and such a quick stance, because that really speaks to the growth of our economy and our ability to compete. But let's talk a little bit about these two words, exemption and exception. It's one that amongst the four of us, we're continuously going back and forth and get each other confused. But Gabe, talk to us a little bit about that.
Yeah, so we're throwing a lot of terms around, and it's you know, we're part of this webinar is to try to demystify the process. So let's try to do that, right? So we're dealing with two different proclamations, and we're dealing with terms such as exemptions and exceptions. So let's try to break them apart. So an exemption is when you are not, when the proclamation, when these orders do not apply to you, right? They don't apply. So for example, on the first ban that we're talking about, the regional COVID-19 ban, that individuals from Schengen countries and Brazil and Iran, when they can't enter the United States directly, it doesn't apply to you in certain situations. That's an exemption. One example is if you are an F1 or J1 student entering for an academic program, it doesn't apply to you. An example of an exemption for that second ban that we're talking about, the labor market ban, that causes you issues. Oops, sorry, I'm having a tech issue. To cause you to not be able to apply for a visa stamp is the physical presence piece. We are, as far as the physical presence go, if you are in the United States on June 24th, 2020, you are not subject to that ban. You are exempt. So that's what an exemption is. It doesn't apply to you. As far as an exception goes, an exception means you are actually subject to that ban, and means you are subject to it unless you can get an exception from that ban. So one of the examples there, so again, going back to our two different bans, the regional COVID-19 ban, if you are subject to it, you can get an exception under a few criteria, such as humanitarian or COVID-19 mitigation. In addition to that, on that second ban, the labor market ban, you know, where you want to apply for that H-1B visa, there are exceptions to that, and that's where we're going to spend a lot of time actually talking about that. We're talking about healthcare workers, critical infrastructure. So terminology plays a huge role here when we're thinking about all of these things.
So now that we have a better sense of the terminology here, when does exception apply? When does exemption apply? How do we get to that?
Well, so there's a way to kind of look at this, as far as, and this is the way we've been kind of looking at it. Where do you start, right? So we're talking about these two different bans. How do you actually practically start your analysis? The way that we think is a good way to do it is start with the visa stamp. Like your employee, do they have an unexpired visa stamp? That's a good place to start. If they already have a visa stamp that they can use to enter the United States, you're really talking about the regional COVID ban, Schengen, Brazil, Iran. And the way you think about it is you first look at that and say, all right, there's a visa stamp. Where are you? Can you potentially be exempt from it? Well, as I said, if you're an F1 student, you can be exempt from it. If you are not, you are probably subject to it if you are in one of those countries. And then if you are subject to it, now you go to the next layer. Consider traveling to a third country for 14 days or applying for an exception. And an exception currently, and what we've learned so far, an exception to the regional COVID-19 ban, the process for that is really to go check with the consulate or even call CBP, call the airport, find out what they require for it. We've been mostly seeing it over at the consular level, and the consulate will tell you what they need. Hopefully you meet the criteria. They will give you a clearance letter so that you can get on the plane with your already held visa and then enter the US. Now, the next layer is, okay, you don't even have a visa stamp, right? So then you start with the other ban, the labor market ban, all right? Can you apply for that H or L, J? The first thing you want to do is look for an exemption.
Wait,
so
hold on. Before you even look for an exemption, can I even get a visa appointment, Gabe? What's going on? I mean, since March, are we even able to get to the consulate and apply for a visa?
I mean, it's a great question. With respect to, appointments these days, the environment has changed. COVID has kind of ravaged the U.S. consulates and embassies around the world. And so you have to be thinking, well, where are you? What are the country conditions? Have they resumed routine servicing? Do you need an emergency appointment, right? So you first think, are you exempt from the ban? And if you're not, and you really need that exemption, you have to do that analysis. Think about what's going on in the country, look at the websites. It all really starts, believe it or not, the websites for the Department of State, every consulate and every embassy are kind of taking it on their own. They all have their own criteria. They're putting it out there. Oftentimes you can email them and get it, and then hopefully you get an emergency appointment. We're going to talk a little bit more about that, and then of course we're going to spend a lot of time on the actually getting an exception to this.
And there's other little nuances here that we mentioned early on in terms of H-1B1s and Canadians. How are they being treated differently when we talk about the labor market ban, Gabe?
Right, so if you don't have a visa stamp and you need to try to get out of this labor market ban, when you're looking for these exemptions, the first thing you do is ask a few questions. Are you Canadian? Canadians, it's been determined that Canadians are not subject to that labor market ban. So they can actually go and apply, for example, for an L1 at the border. The H-1B1s also, you can go and apply for a visa stamp. H-1B1s, those are individuals that are subject to the trade agreement between the United States and Singapore, Chile. We see an exemption there. And then the last piece of it, and this is an emerging thing. I'm not going to spend much time on this, but we should all know there's litigation right now against the government. And the Department of State recently released administrative record that really kind of showed the inner workings of some of these bans. And so what we've learned a few things, and we're learning more, right? So we have to kind of think about that. But we are learning that the physical presence in the U.S. on June 24th does count as an exemption. But holding a visa stamp on June 24th may not actually hold the exemption beyond the lifetime of the current visa. That is an ongoing emerging issue. We are looking into it, and hopefully we'll have more information there.
This is the legal nerd coming out in all of us, where we read the initial proclamation and we realized the author didn't understand how the word and the word or make a difference, right? Because depending on where you were reading, one or the other was being used, and there was no kind of cohesiveness to
Well,
the
it's
proclamation.
also complicated by the fact that the Department of State decided to use their Twitter account to provide guidance and do it to third parties who are not lawyers in ways that were very confusing.
Absolutely. That's a really good point. So we're going to spend the next couple of slides really looking specifically at this labor market ban and the August 12th announcements from the Department of State, where they try to address and clarify what these exceptions were, what they meant, how you could benefit from them if you were applying or trying to apply for an H-1B, an L-1, a J-1, or an H-2B. And remember, this proclamation right now is in effect through the end of the year. So it's for people who don't have that visa stamp, who really do need to be in the States and are going to be asking for that emergency appointment to be made. And they're going to be asking for it based on this national interest exception. And it also means that if you are coming from one of those regions that have the entry restrictions, right, the separate part of this, where you have the 14-day quarantine requirement, if you're getting the exception to the labor market ban, you're also automatically getting a waiver of this 14-day quarantine requirement. So at least it takes care of both of those at the same time. So let's talk about this a little bit. Who does this apply to, Diane? Do we really have an answer as to these exceptions and who it applies to and how they can be done?
Well, we have a general sense. So it's fair to say that those employees who are really crucial to the success of your enterprise, the people who are the job creators, the high-level managers and executives, the people who are the face of your important contracts and client relationships, the people who are at the heart of intellectual property production and creation of patents and things of that nature, are typically a good candidate for this. What's nice about if this exception is granted is that the family gets to come along for the ride. So the lawful spouse of either gender, as long as it's a legal marriage, and any children under the age of 21 get to receive the dependent version of the visa pretty easily. But this term mission critical, and I love the visual, is really the watchword or the watch phrase, because it's got to be mission critical to the post, to the consular post, because they have to be willing to deviate from their usual closure to actually see this person. But then once that person is seen, they have to show that it's mission critical to the company or the organization.
And Diane, if I could ask, what mission critical is partly determined by the priorities of the consular post, but by the priorities of the State Department as well within the visa office. And there has been a sort of hierarchy of criticality. Humanitarian and COVID-19 related healthcare concerns, students come next, and business cases come third. So that should be borne in mind, and we'll touch on that a little bit later.
That's a good point, Angelo. So Diane, with that in mind, if we're considering supporting our associates to come over, should we be kind of championing this new hire, 20-some-year-old grad to get these exceptions?
Right. And with no offense to those who are junior in their careers, the answer is pretty much no. It's probably not going to help the company's credibility to embrace that everybody is mission critical. So if somebody is, at the candidate phase, or they're really junior, they have a very sort of entry-level job title, I don't think those people are going to be likely winners of the NIE, the National Interest Exception.
Right.
Exemption,
excuse me.
No, I'm sorry, you're right.
Exception.
But I take no exception to your correction.
As we
Thank you,
mentioned,
Diane.
those two words have become quite interesting the last few days. So really, we do want to be aware of that mission critical for the company that relates to the candidate and how they're mission critical. And so your new, bright star that you're bringing on board might not be the right candidate right now. But also remember that for now, this is limited. It's just to the end of this year, and really, we're already at the end of August. So think about just logistically moving those dates and thinking about Q1 rather than the rest of this year. But let's talk a little bit as well as part of that mission critical thought and what's being prioritized. There's reference to critical infrastructure sectors. Angela, can you talk to us about that?
Yes, the various industries and sectors that are listed on the screen all come from the August 12th guidance that the Department of State has issued. And if you don't see your industry there, don't lose heart. I mean, I don't see entertainment or the arts or sports listed, but we do have IT, and we'll come back to that as to whether you're really an IT company as opposed to an entertainment company. But the one place to look is the link that's on the screen to the Guidance on Essential Critical Infrastructure Workforce, because it's a wealth of information of occupational classifications that are important to America. And you may be able to find a useful reference with that. And it's divided by industry and sector.
Great. So in the context of specific visa categories, let's talk about the H-1B, Angelo. What are some of the exceptions that probably do apply and we've seen work so far?
Well, I really think that this was something that would be more in Gabe's wheelhouse. I'm happy to do it, but Gabe, are you in the mood?
I am in the mood. I'm happy to talk about this. Yes. So look, there is no exemption, right? We've narrowed that down. We have to apply for an exception to the ban, and we are now looking at the various different types of, the guidance that the Department of State just put out. So first of all, we're looking to see whether or not the individual is a healthcare professional or researchers. This is all related to the COVID-19 response. They would qualify for an exception. The next is, travel supported by a request from U.S. government agency. Government work, interest of the government is going to really play a role. If you can get the government to back your visa application, that's a good thing. The one that we get so many questions on is resuming your employment. Now, let's take a step back for 1 second. It's not just, remember, when we're talking about exception, you have to get the appointment and then prove the exception. Okay, so I don't want to lose sight of that. Sometimes when you look at this exception criteria of resuming ongoing employment, it seems really simple. Well, of course I'm going back to my job. But number one, you have, as Angela said, there is a hierarchy, right? You're looking at humanitarian individuals that are going to get appointments first are humanitarian grounds, F1s, J1s. Then we're looking at the business community. So we have to get an emergency appointment and prove most likely an urgent business need of some sort. Once you clear that hurdle and you can get the appointment, then you need to show that you are returning to your employment. Masa, what's your opinion here as far as, if the Department of State mentioned something about checkbox on the I-129, what's your opinion on that?
Yeah, so we found this troubling primarily because that little checkbox shouldn't really be controlling in terms of deciding if someone is coming back for ongoing employment, right? Because that checkbox, for our purposes, it's technical in nature, right? So it might be that we're filing these changes and not marking continuation, but marking that there's a change because there's a change in work site. And that has nothing to do with the position and the work that the person is doing, but it's a requirement because of current policies by USCIS and the Department of Labor in terms of when you're changing work sites, right? Or it might be changes due to COVID-19, again, not specific to what the person is doing and their work is ongoing. So, kind of it's a problem with these agencies taking on the information from other agencies that they don't truly understand. And we'll talk about this a little bit in the exception criteria later as well. And applying it where it doesn't make sense. So those of us who are on the ground and we know what all of these mean, look at it and say, but that has nothing to do, one doesn't really equal the other. So I take issue with it, and it is problematic. So really at the end of it, it's this full narrative that we're developing, right? This is part of it, but you have to explain, now you have to educate the consular officer that this checkbox doesn't really mean anything. So it's really important to be aware of that when you're doing this.
And one thing I might mention that we didn't discuss, but the consular officer has the approved petition in their electronic system that's called PIMS. And in theory, you could ask for an appointment. They could look at the petition, the I-129 form, see what box you checked, refuse you, and not explain that that's why they did it. So it's really unfortunate the State Department came up with this this test, which I agree with Masa. One agency often doesn't understand the inner workings of another agency or the significance of a form as to why it's being used. And that likewise can be done with regard to a statement about the labor condition application, which is also shown on the H-1B guidance.
Right, and which we're going to talk about a little bit in the next slide. And before we go there, I do want to go back to that first point in terms of healthcare professionals or researchers. Similar to what Angela was mentioning in terms of infrastructure, you can help expand that scope, right? So it may not be the actual researcher who you need in here. It might be your folks who are in logistics, in the manufacturing, in procurement, that are critical to you getting out the PPE or the vaccine that you're supporting or whatever it is. So really, you got to think bigger. And it's, again, part of that narrative, and to try to get beyond these kind of checkbox questions that are really problematic and not realistic in the real world. But let's continue talking about.
Can I just mention one thing quickly, Masa, that's kind of important on this, and just so people can sort of frame the analysis in their minds, and that is that just as you said, the person may be coming to support healthcare logistics as opposed to medical research. But the State Department guidance talks about someone coming to alleviate the effects of the COVID-19 pandemic that may be a secondary effect of the pandemic. So, for example, someone who is going to promote logistics or production associated with insulin manufacturing might well be eligible to come under that classification because diabetics, unfortunately, are a higher risk profile of death or serious illness as arising from COVID-19. So don't give up on the face of the words here and think them through is the messaging.
Absolutely. Thanks for that, Angelo. So walking through the additional exception criteria, technical specialists, senior level managers, and those whose travel is necessary to facilitate the economic recovery of the U.S. That's a big one. What does that mean? Angelo, Gabe, any thoughts on that one?
I'll share some thoughts on it. This is kind of the fourth criteria, which is a factor test. And, you need to satisfy at least two of them. This relates to the economic recovery. It's a little bit, these factors are a little bit interesting. You kind of have to decipher each one. So for example, the LCA piece of it, why is that, why did they come up with that? And it's perhaps because we're talking about recency bias, right? A company that files an H-1B more recently has a need for someone, therefore the LCA is more recent, and therefore they're demonstrating a need for that person, perhaps to facilitate the economic recovery. So that could be one of the reasons why, when we're looking at criteria here, that the LCA requirement is there.
But Gabe, just to go back to that, I think that's really unfortunate that they talk about that factor and give it the significance they do, because someone can apply, an employer can apply for a new LCA and in a week get a new LCA certified, and all of a sudden it seems more urgent. They don't have to necessarily use it associated with a petition, according to this language, and proceed to claim that this is one of the factors being satisfied. So I don't know that the Department of State really understood what they were saying there. As much as I respect them, of course.
Right. It goes back to kind of a reflection of the fact that they are a different agency, right? It's the Department of Labor who issues the labor condition applications, and it serves a different purpose. And Angela, you had mentioned in our earlier discussions that you thought that there was an inference that maybe the Department of State also thinks the LCA is a measure of need and market conditions, but that's not really what it is, because at the end of the
Right.
day, it's literally
Right.
just part of the H-1B requirements for wage purposes.
Exactly. The H-1B labor condition application has nothing to do with the perm labor certification labor market test. The H-1B, by definition, the way the statute is structured, has the presumption there's a shortage if you fulfill a specialty occupation requirement. And so it was just a disconnect in terms of what appears to be the Department of State's understanding of the whole H-1B process as administered by the Labor Department.
Similarly, item 3 with terms of wages being 15% above the prevailing wage, that's an interesting one as well, because as we all know, when we prepare the H-1B, we're making an analysis ourselves as counsel, helping the companies identify what is the prevailing wage, and when we go through the leveling guide from the Department of Labor, and who's setting that prevailing wage. I mean, all of this is just really confounding, because the purpose of the LCA and the H-1B wage requirements is so different than for what the Department of State is purporting to use it for.
And it's also whose prevailing wage. You can use the Department of Labor's wage, or you can get an independent authoritative source wage. And so which wage do we even refer to?
Presumably the one that's on the LCA that we as a council chose to.
That's true.
Presumably one where you can meet the 15% above.
So,
Yes.
so it's all about strategy on your H-1B filings and LCA filings in July and beyond. Let's bring this down to the weeds so people kind of get a sense of what does this mean, all this exception, exemption that we've been talking about, Gabe. Let's talk about some scenarios. So if we have an F1 student who's working on optional practical training, they have their employment authorization document, but they want to travel to China for a few weeks, and then they're going to come back, and it's all going to be in this time frame before the end of the year. They're going to do this in September. How does any of this impact them?
Well, so, the exemption exception difference here plays a big role. As we talked about, an individual coming in F1 status is exempt from that COVID travel ban. And therefore, there's no issue here. They can return back to the United States after travel, providing, of course, they carry the correct, documents that they need for admission.
Including an unexpired F1 visa.
Exactly.
Right. Of course, yes.
So what about the fact that they're going to China in particular? Does that make a difference?
Well, China is China is part of the COVID, the regional COVID ban, one of the countries, very similar to Schengen.
Exactly. So they would either have to figure out that 14-day quarantine period or try to get some sort of exception from the 14-day quarantine period. So even there's logistics that they have to figure out. And remember, there's, I believe, 15 ports of entry where people coming from those areas may enter in. So just even how you're booking your flights will be important. What about the F1 student who left for the summer expecting to return in H-1B status? So they decided they're going to go and in September get their visa stamped, and October 1 come in and start working. And by the way, they're from Brazil.
Yeah, so just being in the United States in F1 status on that June 24th date, we don't believe that creates an exemption for somebody to be exempt from the labor market ban. And because of that, if they travel during the summer and they have their approved H-1B and they want to apply for an H-1B visa stamp, they're going to be subject to that labor market ban. They're going to need to apply for an H-1B, but have to get an exception to it first. So they're going to have to be able to submit exception criteria, which may be very challenging. I mean, Diane made the point earlier, if this is a junior level employee, that may be very tough to show that there's an exception there. Now, coming back to your previous point, if they are able to get an exception and get that visa stamp, they automatically get a waiver of the COVID-19, the regional COVID ban. And Brazil is one of those countries that you cannot enter the United States in directly. So if you get an exception and you get that H-1B, you can come in directly from Brazil.
Exactly. And I'll change this one a little bit. Let's make it someone who's with you on in L1 status, but they were maxing out on their time and you got them into the H-1B program. So let's say they're actually a long-term senior employee who's critical, and you can show their mission critical. So maybe you have a better chance of getting the exception. That scenario would also apply here, right? You'd have to get your visa appointment in the first place, get your exception approved, and then you would also have the travel restriction component covered if you get an exception approved. What about our
That's correct.
What about our H-1B associate who has a valid H-1B visa stamp in their passport? They're in Germany right now and they want to return immediately. They have to get back.
Right. So either they're subject to the first travel ban that we talked about. And so what do? They could decide, well, I'm going to go somewhere else for 14 days. We see that a lot. We've had plenty of individuals travel to other countries. The ones that we've seen a lot of is Mexico and Turkey. Individuals going there, spending 14 days, coming from there to the United States. But this fact pattern says ASAP, like tomorrow, or
as a representative of the Caribbean Tourist Development Bureau, I would say you could also go there.
I was going to
There are
suggest that
several
some of the islands
locations
have
in the
opened up
Caribbean.
some of the islands have opened up their doors. So that's a fabulous idea. But I don't want to, my associate cannot spend 14 days at the beach in the Caribbean. So what can I do?
Well, you can reach out to the consulate, and you have a valid visa stamp, remember. So you are asking them to basically provide you with a pre-clearance letter, a letter that allows you to board the plane, right? Again, it is an exception, but it's, and you have to prove based on various different grounds, and we've covered a few of them, whether it's COVID mitigation, whether it's humanitarian, you want to come into the U.S. And then you can also try, as we mentioned earlier, calling CBP, calling the airport and seeing if they're able to help you out with a pre-clearance letter.
And there's one other thing you can do that we haven't covered, but that is that you could consider CBP pre-clearance. There are 2 airports in Ireland that allow pre-clearance as if you are at the port of entry, but you're still on foreign soil. And if it is a sufficiently emergent reason, you might be able to get a pre-clearance.
I will say we have had consulates be very responsive in that scenario. So it is definitely worth a shot to try that. What about our folks who are in the U.S., but their family is abroad and want to come back in, and they have a visa stamp?
Yeah, so in that situation, we look at the exemption to the to the labor market ban. An individual that's in the U.S. On June 24th, they're exempt. And so if they are exempt, their spouse and children, their family is exempt. So what the family would do is they would try to get an emergency appointment with the consulate, explain that they are exempt because their spouse is exempt. They may have to provide some documentation, and they'll be able to get into that, hopefully, even when routine services are not back, and just emergency appointments. This is an emergency appointment. Family unity is an emergency, and they should be able to get an appointment and then get their visa stamps to accompany their spouse.
Yeah, that was
and that's under
one.
the humanitarian mission critical concept.
That's correct.
That was a big one that was highlighted initially because there was no guidance on that. Let's move on to the L visa category, which is the other one that's targeted by this labor market ban. Angelo, can you walk us through the exceptions for the L1?
Sure. And let me talk a little bit in general terms about the concepts reflected in the August 12 instruction from the Department of State, because if one reads it literally, there appears to be multiple alternative grounds for L1A or L1B eligibility, and those may relate to public health or healthcare professional or researcher that we mentioned a bit earlier. It may relate to a person coming to work on a project or contract involving the U.S. government. And it says travel by applicants seeking to resume ongoing employment in the U.S. in the same position with the same employer, similar to the conversation we just had about the H-1B. The bare language here suggests that it's too good to believe that anyone who is outside the United States seeking to come in to resume ongoing employment ought to be able to get an emergency appointment and a regional COVID exception and a labor market exception all in one fell swoop without essentially showing any kind of criticality or urgency. We are skeptical on the panel that seemingly generous language will apply, but it is there, and it is probably, I infer at least, done for the sake of the ongoing litigation that is existing now against the Department of State and Department of Homeland Security challenging these proclamations and to show that there is a reasonable basis to assume that someone could qualify. In practice is what we'll have to see. But going back to the other one that seems to be the most promising for the sake of the L1A category, it's the 2 out of 3 factor test for the L1A manager or executive. It requires that there be a senior level executive or manager who has spent multiple years with the company as an indicia of having gained substantial knowledge and experience on behalf of that employer, that sort of insider intra-company transferring knowledge that is not replicable in the U.S. labor market. And they will fill a crucial business need associated with critical infrastructure. We had the slide earlier on what the critical infrastructure might be. And so these are alternatives. And I would endeavor as greatly as possible to try and show that all of the categories apply, not just 2 out of 3. I would argue that if someone's been working for more than 2 years, they've been working for multiple years with the company overseas. I would argue that the crucial business need involving critical infrastructure can be related to information technology, because what company isn't an information technology company today? Obviously, senior level executive or manager, that's not that hard to figure out on the organizational chart. So one thing is clear is a new office will not be allowed unless it is extremely, extremely important in terms of the number of new employees to be hired or the criticality of the new operation. When we turn to L1Bs, again, there is the general language about healthcare professional or researcher or secondary effect to alleviate the effects of COVID-19. That still is in there. A government agency request is still in there. Continuing to be an L1B employee in the same position as before because of the perceived financial disruption and hardship to the employer. And then coming again to serve as a technical expert or specialist meeting a critical infrastructure need. And there is a 2 out of 3 test whereby the person can show, excuse me, not 2 out of 3, that was the L1A. There are 3 criteria, all of which must be satisfied. Person is going to make significant and unique contributions to the employer. The specialized knowledge relates to critical infrastructure, and there has been multiple employment overseas. Now, I would say that multiple years of employment, I should say, ought not necessarily be limited to overseas, and it could be a combination of time in the U.S. and time abroad, but because that, by the very nature of the intra-company transferring out classification, is what it's all about. So those are the L1A and B classifications, and they are actually quite promising for creative advocacy and fidelity to the truth, but nevertheless putting the best case forward to demonstrate how someone could qualify for one of these exceptions.
And I'll note that continuing employment with the same employer seems to be a running theme across all the visa categories, right? So we've got the H-1B, it has its own little quirks, and then we have the L-1A and the L-1B. All of those also reference continuing employment with the same employer, and making that argument and including it in the narrative becomes really important there.
I would just offer the caution that an employer should not be too cavalier about continuing employment because, again, you have to get the emergency interview appointment, and a consul may put your continuing employment at a lower level of mission criticality to the consular post than you might.
That's a really good point, and I think it's important to know that it's just one factor of many and probably not the strongest one, but one that should be incorporated. Diane, we know that one of the other categories that does come up for employers at times is the J1, either for the employers themselves or for the employees of the employers. Can you talk to us a little bit about the J1 and how it's being impacted?
Sure. The August 12th announcement opened the door a little bit for various J1s. And just as a quick note, the J1 exchange visitor category is not monolithic. There are dozens of subcategories under the J1, from au pairs and summer camp counselors all the way to postdoctoral researchers. This particular announcement affects a couple of them. So starting with the au pair exceptions, if you're an au pair caring for a minor who's either a US citizen, lawful permanent resident, or even a non-immigrant, where there's any kind of special needs, special education, of course, the child has to be diagnosed and there has to be some kind of evidence of the special need, but that's going to be considered. Also, where the au pair might actually prevent a US citizen or green card holder from becoming a public charge, they're now opening the door there. Also, if the child's parents are involved in the COVID effort, they're opening the door there. Or if it's an exchange program that's actually conducted between a foreign government and any level of US government, state, local, federal, that will work. So that's the au pair piece. On the next slide, we'll see that there are some exceptions now for some other categories. So some of you may have used the intern or trainee category, particularly when people don't get selected in the H-1B cap lottery. So that door is opening a little bit if it's an agency, US agency sponsored program. So it still isn't going to help us so much for the private sector. Any teachers involved in G5 programs, international programs, the door is open for them. And also there's sort of a catch-all. So if the exchange visitor is going to be involved in any kind of activity that will fulfill a critical need or foreign policy objectives, they will be considered as well.
If I might add, the pending litigation involving challenges to these bans includes a friend of the court brief that was submitted by more than 100 organizations led by the Society of Human Resource Management and also the Alliance for International Exchange, and was submitted by our law firm into those two litigations, one in the Northern District of California, the other in the District of Columbia. And we are hopeful that the harm that these particular restrictions on legitimate J1 programs for categories that are excluded will be addressed by the court, because it seems rather arbitrary, and it also seems, as we argue in our amicus brief, that the public policy and public diplomacy concerns of the exchange visitor program ought to prevail more so than merely economic labor market concerns, because J1s really don't compete with American workers. So time will tell how that comes out.
Arbitrary is a running theme with a lot of these policies. So we've kind of talked through the visa categories, the exemption, exception, travel restriction based on COVID versus the travel ban due to market conditions as a result of COVID. But now we have a good case. What do we do now? We think we've answered all those questions. Gabe went through the framework. We did our yes or no's. We've identified a good candidate like Diane told us to. But now what? What do we do now, Angelo?
Well, now we get into the nitty-gritty of trying to be a supplicant to a consular post and get a consular officer to say yes to an emergency appointment. Because the guidance that the State Department has issued on August 12th makes it very clear that the process begins with getting the emergency appointment. And so I would suggest that two steps on the screen, the first two bullets, actually all three, need to be done pretty much concurrently. We really should switch the order of these bullets, because the first thing is to secure an appointment on the online form DS-160 non-immigrant visa application system that the Department of State maintains. And you might say that this appointment suggests that it would be maybe 6 months out in the city where you want to go. If you can find an appointment 6 months out, take it. Otherwise, find another city in the country where you're located and take that appointment. Once you have paid your fee for the application and secured an appointment date long into the future, then you can look for a screen on the system that says, do you need an emergency appointment scheduling? And then you will get a pop-up box where you're going to be given an opportunity to explain the reason for the urgency. And this is where you or your counsel will articulate the wording of which of the bans you're seeking to invoke and which of the exceptions to the bans you feel that you are eligible for. Because essentially, while they don't so much as say this, except in the administrative record of the litigation, they are treating an emergency appointment, a regional ban exception, and a labor market exception as all under the same standards and essentially synonymous. So if you have secured that and you have filled out the box that says, I need an emergency appointment, you should, or your counsel should, go to the embassy website and look for an inquiry email. It may look like something that, as shown here, it may be something else again, such as NIV info or something of that sort. And if we can go to the next screen, there's another way of doing it, and that is, it's an old-fashioned way that seems kind of archaic, but there is a publication one can find. It's listed on the screen, Key Officers of Foreign Service Posts, which is accessible by Google and also at the link below on the screen. And you can send a fax to the consular post through making your request. Now, don't make the pages too long. And bear in mind that the faxes only operate under local time. So if you try to do it during U.S. business hours and the consulate is closed, the fax machine will be turned off. These are the old problems of dealing with fax technology, but you can send it that way. And there will be, usually at most posts, if they issue visas, an abbreviation called CON. That doesn't mean convict. That means chief consul. And you can address it to that person. Now, they may no longer be there because this was last updated in 2019, but there'll be a way to route that to the current chief consul, who would then be able to do it. And here is the key. You really have to show evidence. This is not just saying I'm continuing my same job in the same location for the same employer and give me deference. That doesn't work at USCIS. It won't work at the consular post. So you have to show with metrics on what is the potential for increase or contraction in revenue and hiring. What is the connection to a critical infrastructure need or a COVID-19 remediation? Show those things and you have a much better chance. And then there's going to be ultimately, if you're lucky, you're going to get a visa appointment. And then your candidate has to be extremely well prepared and know how to articulate this, because the internal guidance that was revealed in the litigation administrative record says, if the candidate doesn't give you the right answers, do not ask the candidate or the company to give you anything more. So they're going to make an up or down decision on the strength of that personal presentation at the interview.
So two key takeaways. One is on both slides that in advanced preparation is critical. You shouldn't be pulling all this together after you make your appointment because the timing on this is really important. You really need to have that locked down in advance. And then my second observation is we should just replace this slide with call, Angelo. I think you'll be covered at that point.
Yeah, I'd be happy to take your calls.
Much simpler. So how do you know
this is an illustration of what success looks like, which is something I secured recently on an L1 visa, and pleasantly surprised that we received multiple entry. That's what the M stands for, and the validity period going long into the future reflects, in fact, the grant of a long-term admissibility so that they would not have to re-adjudicate national interest exception eligibility over and over again, unlike what we'll see in the next slide, which I'd ask Diane to address.
So this next slide is for somebody who actually already had an L1A visa, but wanted to get out of the COVID regional quarantine issue. So this is a letter from a consular post to Albert Einstein that grants the national interest exception. And you'll see it's very small print, but you'll see it's only granted for 30 days because the whole idea is my need to travel is imminent, it's mission critical. So the consular posts, for the most part, are putting a 30-day shelf life on this person's ability to get on a plane and come to the States.
Now, what visa category was this, Diane?
This was L1A.
Why wouldn't it be an O1 for Mr. Einstein? I just don't understand that.
I think he probably, given his long tenure with the foreign company, I think he would qualify for either.
I see.
So I will say not every consulate does this pretty letterhead, by the way. Some it's just an email confirmation. So you're not always necessarily going to be looking for a letter. Sorry, Gabe.
And that's an important point because if it's just an email, you're going to have to get past the baggage handler at the airport. And that might not be as easy as one would think. There is an ability of an air carrier to communicate with Customs and Border Protection. There's a special unit called the Carrier Liaison group, and they will at CBP give the carrier a clearance to allow the person to board. The carrier wants that because otherwise they would be fined for bringing in an undocumented non-citizen. Were you going to say something, Gabe?
I was going to ask you, so Angelo, let's say you have this one employer, two employees, facts are the same, they're going to different places. Are you going to get the same result? No, because we have endowed since 1952 in the McCarthy era the individual authority of consular officers to make questions of fact determinations without review theoretically by any other authority, not the president, not the Secretary of State. And so each consular officer has that authority to determine the facts, and the facts matter in the eyes of individual consular officers. But it's sort of like obscenity in that they know it when they see it.
Very good. So, we've kind of walked through these two types of bans, restrictions. And so what does that mean to our employers, Gabe, when we talk about considering your population of H-1Bs and L-1s? Why are we looking at that? What are we planning for? You're on mute.
Sorry about that. So, what we're thinking about, we're thinking about the various profiles. We're thinking about pretty much all the facts that surrounding the various consulates, and right now we're also thinking about really carefully the changing environment. I'm already seeing questions about should we be concerned about this or that, and back to this point about that I'm trying to make with Angelo is that every case is different. We are looking at every case and looking at the facts and trying our best to determine the strategy on pursuing an exception. And it depends on the the circumstances around the industry, the specific job that the person is doing, their qualifications, the environment where the consulate is located. So we're just very careful about every case is basically a snowflake, and we have to pay attention to all the details.
And let me mention something that may not be well known, but just consular officers are not at the same level as USCIS adjudicators in terms of the eligibility criteria to get the job. They are often extremely intelligent. Oftentimes they are lawyers.
Careful, Angelo. We still are looking at our petitions at CIS.
Those two are sometimes inconsistent, being a lawyer and being intelligent, but they have to take a detailed test and a screening to get that job. So treat them with the respect you would give to someone who is not going to be easily snowed and will look at the record.
It's a really good point. I will say as well, when we know a lot of companies already have their own travel restrictions, right, because of COVID and for safety reasons. As you're opening back up, as you're authorizing travel, being aware of who your H-1B and L-1 workers is important as well to really make a determination, is it necessary for this individual to leave now? Because if they do, logistically, how are they going to come back in? And that's really important for you to identify that population. And have a plan and protocol and governance in place for when and how and why individuals in those visa categories will be asked to travel for company purposes. Personal, travel is another question if people are traveling. Some of it is due to emergencies that come up with family members. Some of it's a vacation. Maybe the vacation isn't necessary right now outside of the U.S. Maybe you don't want to go through the logistics and the hoops you have to go through to get exemptions and exceptions, et cetera. So it's really helpful to know this in advance and plan for it in advance. Angela, this metrics around revenue and hiring expansion or contraction, why is that important for us to be thinking about right now?
Well, the labor market ban is one that is expressly premised upon the danger to the U.S. economy and particularly to unemployed U.S. workers. And to the degree that you can show that you'll increase revenue, and that increase in revenue will lead to increased hiring of American workers, that is a strong point in favor. On the other hand, we also want to be able to show that a denial of the request for an exception might lead to a loss of U.S. jobs and a contraction in revenues. And so it's really important to speculate, and it doesn't have to necessarily be with the kind of scientific precision that a forensic auditor would require, but just a reasonable factual basis to say, this is what we think will happen if we have this person situated in our U.S. office or working in the United States to achieve the desired business objectives.
Thanks, Angelo. And as we're coming close to an end, we're going to take a few minutes and answer some of the questions. I'm going to let Angelo and Diane walk us through some of the questions that people have submitted through the presentation.
Sure. I'll begin with an interesting one. Just to clarify, is it still an open question whether someone with a stamp as of June 24, a visa stamp, which has since expired, may be subject to the executive order if they depart the U.S. and need to reapply for a stamp before returning? Well, let's break that out. If they were in the U.S. on the relevant date of June 24, then they are not subject to the labor market ban. However, they're still going to have to get an emergency appointment since they need a new visa. And if they happen to be applying from a country subject to the regional geography ban, then they're going to have to show an exception to that or quarantine in a third country for 14 days. And someone else asks whether quarantining in a third country for 14 days works. Yes, it works, and it can be especially good to one's morale if it's in a warm climate where one can relax and think deeply at deep thoughts about existential reality in the midst of a pandemic.
And Angelo, let me just tack on to the previous answer that you gave. And this is piggybacking on what I said earlier. because of the litigation efforts, we have been seeing some new information coming from the Department of State relating to that second part of the exemption, which is holding a visa stamp as of June 24th, particularly if you are not in the United States on that day. And so that is an evolving issue. There's, some of the information is saying that if you're outside the U.S. as on June 24th with a valid visa stamp, you may not be able to renew that visa, that the exemption only applies for the duration of that visa stamp. More to come on that. That's an evolving issue.
And that, I think, is not the fact pattern in the question, though, because that person was in the U.S. at the time. But thank you for your clarification. Another question is, if an exception is granted on labor market, then that automatically grants an exception on geography, ? It seems to be the case. The Department of State's administrative record has said that. What is not clear is whether the person has need of a geography exemption and has never been measured against a labor market test because they have a valid visa. My reading of it is that these are synonymous, and if you get an emergency appointment, you're likely going to get a geographic exception and a regional exception as well. Are all physicians or healthcare workers part of exceptions, or just ones on the front line directly responding to COVID, or those with a specific specialty? Well, again, it's very clear that if you're responding to COVID, you qualify. But if you are involved in a field of research or patient care that or logistics in the production of medical products, that you could qualify by showing that your contribution is to a factor in healthcare generally that would be beneficial in the fight against COVID. So if your product or service is targeted to at-risk patient groups, the elderly, those with asthma or lung problems or diabetics, then you might be able to qualify as well. I don't know if anyone else has any different thoughts on that.
No, I agree. I think in any one of those instances, you really have to expand the scope yourself, and it's not as narrow as it's stated to make your case, absolutely.
And Gabe, here's one for you. What is the checkbox question? That wasn't something that people understood.
So going back to the exception related to resumption of ongoing employment, within the Department of State guidance, it basically said one of the things that they look at is on the I-129 form, have you checked off continuation of previously approved employment without change? If that box has been checked off, that is an indication to them that you are actually resuming employment. Seems a little silly, right? It seems a little short-sighted because, of course, somebody could be in the same, someone could have changed employers and the box that's checked off is change of employer and they've been in the same position for a year and they're traveling and they're coming back to the same role. Of course, advocacy is going to matter here. So it does seem a little silly, but that checkbox question is on the I-129 and it comes from that Department of State guidance.
Here's another question. What about a permanent resident stuck outside the United States for more than 6 months? Is their permanent resident status in jeopardy? And has USCIS made any concessions in the physical presence requirement for the naturalization application? Permanent residents who are outside the United States for more than 6 months are treated as arriving aliens and therefore subject to greater scrutiny and fewer due process protections. On the other hand, a green card is a travel document if you've been outside the U.S. for less than a year. If you've been outside the U.S. for more than a year, you can get a special returning resident immigrant visa through a consular post, and those are given some level of greater solicitude in connection with the mission critical elements of the scheduling of interview appointments. As for any special concession about the physical presence requirements, I don't think you're going to see that. That's statutory. It's not something USCIS is going to elastically change. Masa, did you want to ask any of the review any of these questions, or you want me to keep going?
Actually, we're at time less than a minute left, so I just want to thank the panelists for joining. I think this has been a helpful and lively discussion. Always like your colorful comments, Angelo, and thanks to everybody who joined. We hope that this was helpful and useful. At the end of the day, this is continuously evolving with all the posts and updates that are issued. And there's aggressive stances to take, and then there's ones that you really want to be more thoughtful about when you're pursuing these exceptions to some of these travel bans and restrictions. Be on the lookout
And the
for
CLE
future
code?
pop-ups. Oh, I'm sorry. Thank you for that. The CLE code is SS Seyfarth Shaw 5571. Again, that's SS Seyfarth Shaw 5571. Thanks.
And don't
for
spell
joining.
Seyfarth Shaw in full, it's just SS.
Thank you all. Bye.
This concludes today's webinar. Thank you for attending.